a new intro.
So fancy.
Right? I feel so
Very.
more legit now. Good morning, everybody. This is another Tuesday Talk for Empower Events Tampa Bay. We have a very special guest today. I'm so excited to talk to Kunbi Adupugun, Esquire.
Yes.
Tons of experience. She is the founder of Legally Set. So that is all templates for business owners to be legally set. So you have all your ducks in a row. And we're so excited to have her today. So Kunbi, would you please introduce yourself?
Thanks, Ashley. Thank you so much. I am so excited to be here. And so you already did half of the work for me already. But my name is Kunbi. My name is Kunbi Adupugun. I am a business attorney based in New York. I have been practicing. Actually, tomorrow will be my 10th year on admission and 11 years on my firm. And so this is really exciting. I can't believe it because in my mind, I'm young. Anyway, I am a business attorney. A good chunk of my practice focuses on not just entrepreneurs, but event pros specifically, because I have been in the events industry for 8 years now. I am the founder of Perfect, which was originally called Isle Perfect, a wedding blog and now events blog that features the best and stylish upscale events around the world. It's my baby and one of my favorite things to do. It's basically the perfect fit. And so I am, like I said, I am also the founder of Legally Set. It's a contract template shop that offers ready-to-made digital downloads of thorough as F attorney drafted contracts. Basically yes. Oh no, I'm one of those. I'm one of those very serious people when it comes to contracts, obviously. And so there are industry specific, super tailored contracts for whatever particular position you occupy in the industry. So if you're an event planner, there's a contract for you. If you're an event planner that also offers floral designs, there's a hybrid contract for you, for photographers, for designers, and for entrepreneurs, creative entrepreneurs as a whole. So I do believe passionately that everybody should be legally set for business. It's not something you should forget. It's not something you should look over, because you take yourself as seriously as you want people to take you, and protect yourself the same way too. So I'm glad to be here.
Yes, thank you so much. We're so excited to talk to you about contracts and specifically how, we're still navigating COVID in the event space and what we can be doing to make sure that our contracts are set. I want to talk about COVID waivers and anything that you've seen as a trend so far. Let's say, like, if a client wants to require that vendors and guests sign a waiver to attend or work the event, what should that COVID waiver cover?
Okay, sorry about that. I wanted to unmute myself, but that is a very good question, because that's a question that's been coming up a lot so far. A lot of questions around what liability waivers are and what they would cover. Because COVID is a highly communicable disease of which, like, technically there is no cure. Not technically, period. There is no cure. It's a fresh thing. We're living through hell right now in terms of the pandemic, and obviously with a delayed vaccine rollout, there's also that there is no widespread vaccine technically right now that's readily accessible. So these are the things that you have to bear in mind when you're a service provider or someone that's doing or hosting something that involves person-to-person contact in some way or the other, and people communing in together in light of this because of this pandemic. So with a COVID waiver, the most important thing that everybody should think about is the idea around assumption of risk. Like the whole point of a waiver is that there are two prongs to it, in that you're telling the person that they do know that there's a risk of catching this communicable disease, and they're assuming that risk by coming and attending this event or attending this space. That's technically what it is. And then after you have assumed this risk, you're waiving and releasing the person that is hosting this, or the person that's carrying this space, from having to be liable for anything that does happen if you do contract the communicable disease from participating in this event. If you remember, you can liken it basically to when you partake in certain things, like certain dangerous activities, for lack of a better word. Like, for instance, if you are maybe bungee jumping. I know that that's a random idea, but like something that I believe, like, even when you go wine tasting, sometimes you'll find that they will have like an alcohol liability waiver, just to let you know that, hey, yes, this is what we are offering, but the truth is you are assuming the risk here, and you are of drinking age, and that you're assuming the risk here. So first things first, like I mentioned, was assumption of risk. The second part being the waiver. The other part is something called indemnification, basically saying that you are going to hold the company harmless for anything that relates, like anything that happens in the course of the event that is not like gross negligence or something that they directly do to you in some way or other, or cause to you. And that you're not going to hold them responsible, either their employees or their contractors, etc. And lastly, one of the most important things is also you attesting that you do not have COVID and you are participating, basically a discussion around your health condition, that you are attesting that you have tested and you know, and to your best ability and knowledge, you know that you do not have COVID-19. You have not been outside the country, for instance, or been in contact with something within 14 days of you attending this. These are things that are important, because then you're able to show that you as the service provider or the venue or the beauty provider, whatever it is, you're able to show that this person attested to this, and this person consented to this, and this person knew the risks by participating in the event.
That makes so much sense. So they're signing off the waiver, and they're saying, look, I assume this risk. I know that it's a possibility. I am not currently positive. And if I were to be positive, that I will not hold you responsible for any, damages or anything like that. So that's a pretty big deal. And like you said, it is normal within a lot of other industries. So you go bungee jumping, you go on an excursion on a cruise, you go wine tasting, you have to say, look, that things could happen here, and we have to all be on the same page about it. We have to all understand that there is a risk here, and this is exactly how we're going to take responsibility for that risk. And I think that's exactly an important conversation to have.
I think so. I think it's something that obviously there's a whole story about how there there's one thing I always need to say, first of all, is like laws are very state specific. Like, even though there are common laws in terms of like the federal stuff, for instance, in our contract templates, we're very cautious about putting in all the general language so that whichever state that you're trying to go, then you can tweak it as necessary. But the thing about laws is that a COVID liability waiver could be functional differently in different states, for instance. And there are some states that might not even necessarily need a COVID liability waiver, because there's already some kind of limited liability protection in there by their state already. For instance, to minimize what a service provider would actually be liable for. So sometimes you might not need that. But what I love about a COVID liability waiver is that it's just this extra piece of document that you can show to show that somebody consented to participate in an event with knowledge.
Exactly. It's extra,
it's an extra buffer.
Yeah. And I think it's just it's a good opportunity to really get eye to eye and be like, okay, remember, we're still living through COVID. All right, because it seems like people are kind of used to it now, and maybe more relaxed. And I think it's a good opportunity to say, look, we're going to sign this because remember, this is what we're going through, and then it just protects you. So I think that's a great idea.
Yeah, and it's like you just hit the nail on the head, Ashley. It's also an emphasis. Like when you're emphasizing something to someone, it's like a double reminder. Like, do you know what I mean? Like, it's something that's impressing upon them the seriousness of a situation and the seriousness of an event, so that they can act accordingly as well. So even it's something I say about having super concrete contracts. And I know I'm deviating here, but it's the same thing. Like, you put certain things in the contract, not only for the legal protection, but also to emphasize a particular point and to emphasize the procedure and how things will be handled. So that's exactly what it is.
Exactly. My cooperation and consultation, mine is the biggest in my entire contract, because it says and look, we gotta go through this together, because this is how it's gonna work. I am not responsible if your mother-in-law doesn't show up. You can't hold that against me. All that kind of stuff.
I love that.
Yeah.
Oh my God, I love that. That's a great idea. And also, so along with that cooperation, I love that you have a cooperation clause, by the way. That's something that I feel like I'm going to add into mine too, because that's amazing. But also, I love the no clause. Hello.
Oh,
I love a no clause. That's what, so it goes hand in hand. You don't have, basically letting them know what you will not tolerate and what you will not be providing in terms of a service. Because people, in any profession, this is not even just an event pro specific thing. I'm pretty harsh on event providers, because I feel like a lot of times they focus on the fun and happy parts of things and neglect their own legal protections, and forget that they probably have one of the most serious jobs in the world, because at the end of the day, the client satisfaction is peak, and anything can trigger a change in mood or a change in satisfaction once the service is provided. So for me, it's always, the reason why I'm saying that is because, like, with any industry, with any contract, you always find a situation where people try and creep into the scope that you're doing, and they start adding all the other stuff that wasn't included originally in the original agreement and arrangement. So the no clause for me is always the one where I'm like, I am not a florist. I do not provide floral services, and neither do I do setup or breakdown of floral arrangement. So you make that, this would be a florist, you will need to contract with the florist separately. Or I am not a DJ, my band, my blah, 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 it does not provide DJ services or MC services. You will need to make that, or assign someone in your party to handle that for you. So I think those things are always important. Make it clear. At least make the ones that you know are clear, because then that will set the tone for their expectations.
That's so smart. I love that. I'm gonna have to add that. I have to get the set and like hybrid them together.
Yes, exactly. It could be exactly, because it's the same. For you, it's a cooperation clause, but the reason for that is because you're letting them know what. So you could make your hybrid too.
Yeah. And do you suggest that? I feel like, so I've been in business about 8 years, almost 9. And so that's kind of, I look at my contracts as a living document. You know, it is something that
ma'am. Oh my God. My favorite.
Yeah. So, and if, you know, if you hear a horror story, it goes in the contract. If you experience something, okay, that updates the contract. You know, COVID, I updated the contract. So I feel like it's sort of like a hybrid of things over the years. So would you suggest getting your specific legally set templates and then kind of maybe paying for an attorney to review and kind of putting them together?
100%.
Okay.
I think, like you said, you just hit the nail on the head. A contract is a living document, but one of the dangers with having a contract and having it, like you changing it yourself, is that you're just putting things together, and I call it the hodgepodge. But the truth is, you also want to make sure that they're not contesting with each other, because clauses can fight. I call it fighting clauses, because sometimes, like, a clause will say something and then the other one will say something just a little different, and then they're fighting each other in terms of how the procedure will handle. A confusing contract is a weak contract. So, like, you want to make sure that you have, maybe, like, obviously, even if you purchase a contract and legally set, there are clauses there that you might find interesting or whatever. But it's always a great idea, like, if you are finding yourself in a situation where you are, like, you know, you've been updating over years, especially for you, for instance, like, you've been in business for 8 years, having someone sign off or having someone review it for the legalities and for the effectiveness will always be a great idea, because there's nothing more beautiful than one-on-one care. We all know this in any kind of business. So having an attorney even know that, okay, you know what, Ashley is legally set, is always, I can never say no to that.
Yeah, I love that. Okay, that's great advice, because I think there's a lot of different levels of people that, you know, we work with in Tampa. It's such a growing industry. It's a growing market. So I think there are a lot of people that have been doing this for a long time, and then there's a lot of people jumping in. And so I think that's great advice no matter where you're at.
Yeah, it's like, like, it's like your hair. You have to. Sorry, I didn't hear you, Ashley. I'm sorry.
Go ahead.
No, I was going to say that it's like getting your hair done. Like, there's maintenance involved. So there's maintenance with your contract as well. And given the,
absolutely,
God, I was about to curse, but given the year we've had, like, you know, given the year of changes, not just in your industry, but around the world, it's really important that you at least you get things fine tuned.
Exactly. It's like one more layer to help you sleep at night in this crazy time. Man. So speaking of this crazy year, what has been your biggest challenge this past year?
So my biggest challenge has been, my biggest challenge for me was, to be honest with you, was transferring, like, converting my practice into a virtual practice. Like, it wasn't too much of a challenge, but, you know, with lawyers, we have a lot of documents, and, like, you think about it, like, you always know that your office is going to be there. But, like, knowing that, especially since I've been able to help a lot of attorneys, or like a lot of people around the country, but not only that, I'm admitted in 3 states. So having, like, to just, you know, like, come to terms with, like, you know, getting everything, like, virtual completely was a chore in the beginning, but it's been the best thing. I don't think I'm ever going to go into anything else. It's going to be my practice is going to be virtually, like, legal, like, it's going to be a legal practice virtual. I literally just like, I think this is the first time I'm saying it, but I literally just put in my notice at my firm after 10 years. So I'm starting my own practice starting March 1st. And so this has been the best year in that regard, converting into a full virtual legal practice. And I'm launching that in March 1st. So I'm excited.
Oh my gosh, congratulations.
Thank you. Oh my God. I'm taking congratulations now. The last
right?
2 weeks, I was freaking out, like, because you're used to being in a normal, like, the structure and safety is always, I mean, who doesn't love that? And the known is always more comfortable, but
yes.
Here we go.
Yeah, you were forced to be able to be, more streamlined and efficient, virtual, you can do anything anywhere. And now that's like a great foundation for you to jump in and doing your own thing. Exactly. That's so cool.
Exactly. So I'm excited. Thanks, Ashley.
That is awesome. Congrats. March 1st is also my anniversary for my wedding. So,
hey, so it's hopefully a lucky day. Thank you.
It is, yeah. Awesome. So I've got a few more questions that we've kind of gathered up from everyone in the week leading up to this awesome interview. The biggest challenge question was a big one for everyone. We talked about waivers. Let's see. Then we've got this other question here. As creatives, vendors, and the such, what effective COVID-related language should we be including in our contracts to protect ourselves, but also to allow our clients to feel comfortable? So I think this is really ties in with the waivers and having that right language to have the opportunity to make sure everyone's on that same page.
Yes, completely. I think that that's a very good question, because there's been a lot of things that have, like, been necessitated, for lack of a better word, so that you can protect yourself. But I know that everybody's also obviously wanting to make their clients feel comfortable. I think, first of all, having a solid, and this is not in order, I'll tell you that, because I always just go based on what I remember first. But the first thing being a very solid and clear to understand force majeure clause. Force majeure means major, major force, because force majeure, it's basically a major intervening force that happens that throws things off for the loop and is not actually precisely anybody's fault. It's something that happens that you have listed in your contract that says, okay, something hit the fan, and here we can't have this event exactly when we said we were going to have it. So
hurricane,
more than anything, a lot of people talk about the force majeure clause, and they're always saying, oh yeah, go like force majeure, force majeure, force majeure. But the truth is, a force majeure doesn't necessarily mean that the event is canceled. It just means that the event is unable to happen right then. There's something that's interrupting the performance of an event. So having a step-by-step process as to if whoever is impacted, can then notify the other person within a timely manner, like an immediate manner if possible. And then also listing what happens and what procedure will take place is always the easiest, so that you and your client aren't fighting over this when the time comes. Like, we have no excuse anymore to keep it too general. So first things first, you will define what a force majeure is. Does a force majeure include a pandemic? More importantly, because we are living in a pandemic now, it's not a surprise. What is a surprise and what could be a surprise might be a government lockdown. Like if a government decides that they want to lock down again, because then you are literally you're unable to perform. The truth is, there might not be any more lockdowns. There'll just be government restrictions. So depending on that, you might want to have a clause about government restrictions, or you might want to have a clause about a minimum guest count. But that's a different story, because that's something you really should explore. Because what I mean by that is, now government restrictions do not stop an event from happening. It just means that maybe they are happening at a littler size or something like that. So that's just something to bear in mind. But beyond that, with a force majeure, you should also list how you would handle how this stuff will happen. Like within how many days will a rescheduling occur, or within how many days would they have to at least even have the discussion about a rescheduling? And if in the event that they need to reschedule due to a force majeure event, do you want to specify that and tell them that, oh, they have within a year to reschedule? Or do you want to just let them know that in the event of a postponement, then the normal postponement rules of your contract will apply? You can do that as well, so that you can keep it all in the same and say, regardless of a force majeure event, the normal postponement clause of my contract will apply. You can, everybody has options there. Do you know what I mean? So that you can keep it tidy. The same thing happens with the cancellation. In the event that the event is not postponed, then what happens? Is it a cancellation, or is it still going to occur? This leads me to my next thing, your postponement and cancellation clauses. If you're listening to this right now, go ahead and go fix that, because you probably haven't since the year has happened, and that's a dangerous game to have. have going, because you want it to be as clear as possible what happens in the event of a postponement. Like, what happens? Do they have to notify you within this? Will you, in every circumstance, transfer services to the next date within a particular period? Like, is it a 6-month period? Is it a 12-month period? And in the event that they cancel, regardless of what the reason is, what happens? Or if they're canceling for force majeure, do you make a different concession there and give them their money back? That is, I mean, I know a lot of people have been making decisions. I can't tell you which one to do, obviously, because as a lawyer, I'm just like, get your money, get your money, get your money. But for a lot of people, that is something that they need to think about in terms of, like, empathizing with the client and everything like that. So it's a business decision, but it should be very clear in your contract. So there's no reason why. Exactly. Yeah. There's no reason why your client should be trying to reschedule, and that's the first time they're hearing about a rescheduling fee. No reason, because that's the reason why they will fight back, because then all of a sudden it looks like you're taking advantage because of the circumstance. If you are charging a rescheduling fee, it needs to be clear in your contract. If it's a percentage, let them know it's a percentage. If it's a fixed retainer, let them know it's a fixed retainer, so that all terms are clear from the minute that they contract.
Yeah, it's like the same thing with the waiver. It's like, hey, no, remember, I can point back to this time and document that said that we talked about this. You can't have amnesia. Like, it's here. We talked about it.
And you're exactly right, because I think that one thing that everybody has, even I have it, like amnesia. It's like, God, wait a minute.
Puzzle pieces for an event. Yeah. Like, who's doing what.
Exactly. So having that is also the first line of defense, because most of the time what will end up happening is that the client goes and has their contract reviewed before they start any fight with you. And in that part, it already buffers you from a lot of conflict and having to be the bad guy, because your contract is very clear about how the procedure will work. Exactly.
You can't argue about it. We all agreed to this. I like that. So having very, very clear language about the force majeure, is it canceled? Is it rescheduled? What do both of those things mean? All at the outset, so that you're not, arguing about it later.
Yes. So another COVID-related thing that's not necessarily COVID-related. I've already spoken about the postponement and the cancellation and the force majeure. I feel like they come as a group now in general as things you want to tighten. But having a safety clause in your contract is always really important as well. Saying that some people call it a safe working conditions, whatever it is, but it's a clause that basically says that you will not put yourself or your staff in danger in any form. So in the event that there is a situation that occurs in your at the event or leading to the event that does jeopardize the safety or health of your client, because you have to remember, you are responsible for not just you, but the people that you employ. So because you are making them come to that event. So you have to always remember that. So there's already, you have to always do the best thing for them. So in the event that the safety of your staff or you in any way happens during the event or before leading to the event in any manner, you do reserve the right to suspend or terminate services immediately after notice. Yes, without refund. You will bring notice to the client, of course, because you just don't show up. You bring notice to the client and let them know. If client does not cure the situation, then you are legally permitted to leave or to suspend such services immediately. So it's something that you should, something like that, having that safe working conditions. Obviously, that is in our legally set template, but it's something to always to bear in mind, because now you're thinking about not just providing the service, but also protecting the people that work for you in the event that something, maybe they're not complying with a certain thing, like one of the state regulations that are necessary for you to be in an event in the first place. There are people that have really severe health conditions. There are people that you have to bear in mind, but also for your sake, you want to make sure that you have a procedure in place that if in the event that, because there's a lot of stuff in the air right now. There's a lot of stuff in terms of how the courts are going to handle the responsibility of the party who is hosting the event or monitoring the event. So you don't want to be caught on the wrong side of that. It's always great to have some kind of procedure in place so that in the event, worst case scenario, that you have to show something, then that's something that you have to show that we were conscious and we did make these steps. And the client was the one that tried to jeopardize us. But you know what? Then we got the F out of there.
Yeah, exactly. So I feel like from personal experience, it's been tricky because there's some people that have been very responsible and very, aligned with, how, you know, I feel about precautions and things like that. And there's people that haven't. And so it's like, I've had to decide knowingly before going to the event that it was going to be more risky. And then sometimes when I'm there, it's even more risky than I had imagined with, you know, lack of precautions. And so I do have that in my clause, my contract also, but I feel, how do you enforce that? And what would you say if you are caught in the moment and you wanted to terminate service and just be like, look, I can't, it's not safe. You know, have you ever had to deal with that?
Yeah, so with that, I was in the Clubhouse room, I think last week or 2 weeks ago, where vendors were talking about that. Obviously, I'm not an event professional, like event vendor, like I don't plan events, so I don't know. But I have seen, I have heard people talk about it, and it's like, first of all, technically with the legal step, the first part is notice. So you provide notice to whoever the points person is for the actual couple, like the clients. Usually, sometimes it's the couple, but sometimes they will assign someone who's the person that you're going to communicate with. Obviously, as a planner, sometimes you are the points person, so you will decide who the points person is. This is the reason why, and I know some lawyers might disagree with me because it's like, oh, well, we're doing too much. But I think it's really important to have client education before, like, you know, not just before they sign the contract, but before the day, so that you're emphasizing this point that you have to remember it is also your responsibility to make sure that this event is, like, you know, where everybody's following the rules, because they're your people, they're bringing them into this space. So you have to remember that who is the points person? I will be communicating with this person if anything is going left. It's the same thing. And this is not even just limited to like the COVID situation. Like if somebody has, for instance, I know that there are some people, like obviously guns are legal, possession is legal around the country. So in a situation where maybe you don't feel safe because there are, like, you know, people are intoxicated and there's, like, you know, stuff happening, or people are harassing your staff, notice needs, like, you bring notice so that they can maybe discuss that. It's like, that's a good duty as a service provider. And then after that, if you could decide that you want to notify more than once just to get everything going, but then you do have the right. You do. I literally I don't know how legal this is, and this is not legal advice, but I literally was listening to a Clubhouse room yesterday. A photographer said he walked away and deleted their files immediately. I'm like, wait a minute. He was physically harassed. So he was physically assaulted, I think. So that was like obviously even a more escalated thing. You are always protected in the event of a crime, obviously, because a crime against you is a crime against you. But in a situation where there is a higher risk of something happening, in imminent danger to your health or your person, then you are able to leave.
Yeah, if there's, you know, a questionable sparkler exit situation or something like that.
Yeah, they better run.
Make it known, bow out. I like it.
Yeah, I'd be like,
oh my gosh. Awesome. Well, speaking of, you know, businesses that have, you know, other people to protect, we have this question. As business owners with employees that have subcontractors and 1099 workers, what types of agreements do you recommend having in place with those people that you're bringing in?
Okay, this is a really good question, because this is a question I get a lot. And if you go on Legally Set's Instagram, you'll even see it. I think it's one of like the last 3 slides I've done in terms of the 5 essential contracts that you will have in like you should have as a business owner, because people are always trying to, like, you know, save their money and things like that. But I think it's really important for you to have those. As a business owner, you already know that there's a difference between an employee and a 1099 worker. A 1099 worker is someone that's contracted in some form. So whether it's a main contractor or a subcontractor, depending on where they fall under your space. Sometimes the main contractor is the one that subcontracts. So they will be the ones with the 1099s to the subcontractors, and the primary person is the main contractor. So in that case, obviously, and those, like you said, they're the same thing, and those are who the 1099 workers are. You have to be very careful with employee versus independent contractor relationships. In states like California, almost always, this is not legal advice, almost always they're now employees. So you have to really like explore that and make sure that you're not deviating from that. In states like Connecticut, for instance, they have an ABC test. If you Google the ABC test for Connecticut, you will see what it means, and that's how they differentiate between an employee and a contractor. Because that is the difference, and you do not want to be caught slipping there, because then you're liable for a whole lot of money. An employee is someone that works for you. It's somebody that works for you, has an employee agreement with you, and is somebody that is obviously due more in terms of a duty of care, a duty of everything, a duty of like an employee, for instance. A lot of times, many employees, depending on the state, might not be able to sign a liability waiver. Because the truth is that an employee is mandated to be there because they are an employee. You have an unfair leverage in terms of forcing them to be there to employ. And they know that, okay, it's either my job or this. So there might be some states that frown on an employee liability waiver. For instance, there's some states that frown on non-compete agreements. So you have to just like, non-compete clauses might not be valid in certain states. So these are the things. And it's sometimes it's a quick Google, but this is the reason why we recommend. This is the reason why attorneys are kept in business, because sometimes you will have to hire because you don't listen, the money you will save by consulting with an attorney in the beginning and the money you're going to lose when shit hits the fan. Sorry. One thing I always say is I fear two things. Well, now I fear three. I fear God, I fear the IRS, and now I fear my 3-year-old boy because he's a mess. So those are the things that you have to now really just keep in mind when you're creating those relationships. There are meatier things we have in an employee relationship, like an employee agreement. All these agreements are available and legally set, but there are different things that you have in both, because an independent contractor is independent by every mean of the word. Independent in terms of their email, independent in terms of their taxes, independent in terms of their work hours, independent in everything. They're independent workers that you are contracting with to accomplish a task. An employee is someone that's working under your brand, under your business, and carrying out the job. And you're providing them, in consideration for this, you're providing them with different benefits, you're providing them with a fixed salary, and you are entitled to a particular kind of representation from them because they are your employees. Their actions will automatically be, depending on what it is, obviously. And if they kill someone, that is not your business. But your actions would automatically be speaking towards, they have agency over your company in terms of how they behave and how they handle things. So these are things, there's obviously a higher stake here. There are obviously so many benefits in terms of loyalty and things like that. But these are things that you have to consider. So those two, for a hiring agreement, you definitely need, whether it's an employee or an independent contractor will determine. There's also obviously, in both contracts, for instance, both contracts on the legally said there are confidentiality clauses, but there's some certain instances where a business owner would need an NDA. For instance, maybe you're having pre-talks in some kind of way. If you're having any conversation that involves proprietary value, in which there is no clause that is separate that confirms or protects your confidentiality, this is a reason to always have one in your arsenal as well.
That's perfect, because that was a question. It's why and when would you have an NDA? But I think no matter what, you have an agreement with anyone that you're working with, have it specifically for their role, and then also you need an NDA.
Yes, you do need an NDA. Sorry, I'm trying to get you guys the link so I could drop it here, because I did a reel on my only reel that I ever did, because now I'm still recovering from it. But
no, I have not done
because
one yet.
It takes so much. It takes so much out of you. But an NDA. You need an NDA for many reasons. Don't ever think otherwise, guys. But an NDA is really good when you're pitching your business for something, when you're pitching an idea, or when you're sending, for those people that are now product-based, who have pivoted into product-based entrepreneurship, especially when you're buying things from China, send an NDA ahead of time so they're not sending your design files around. Obviously, sometimes, this is all US-based agreements in terms of that. And so you might need to comply with the laws in the other countries. So make sure of that too. And then you also have to weigh whether or not it will be effective with these Alibaba vendors, for instance, because I know a lot of people contract with Alibaba. And then another thing is, if you're bringing on an employee and you want a more robust confidentiality statement, then obviously, please, by all means, make sure that is clear. If you're bringing on a contractor and you want something more robust, an NDA is always a great idea. An NDA is great if you're selling your business. If you are looking to sell your event planning business, I know a lot of people have done that over the last couple of years. You want to make sure that you have covered everything in terms of that. Or maybe somebody's trying to acquire you, or somebody's trying to pitch a partnership. A lot of people are partnering with other people in their same exact position or industry. It's always great to put an NDA there, because people forget. And they always now decide that, oh, I don't remember us discussing this. Put it in writing so you have receipts.
I like that.
Yeah.
That's awesome. I'm excited to see your reel too.
Oh my God. Oh my God.
Scared.
I was like, oh my God, I'm 34 years old. What am I doing? And I'm like, At least I didn't dance yet. I'm still trying to figure out my dancing TikTok, but we'll get there.
Oh man, I don't dance. That's for sure.
Oh my god! Like I don't dance coordinatedly, and
No.
like it's just going to end up not being okay. So I don't know. I'll figure it out.
It takes so much concentration
and so many hours. So that's stress. That's
how long did
stress.
it take you to do one reel? So it was like what, like 30 seconds is a result, right? So
yes, I did. I recorded it 3 times, but to be honest, mine is the most like dorky lawyer. I just recorded. I think I recorded only like 3 times. It took me like 10 minutes, and then I found someone on Fiverr to flip it for me into a reel. So yeah.
Oh, that is smart. I like that.
Yes, I'm all about working.
Yeah.
Things that you know how to do. Anything else, I'm like, hey, so it's $10. Okay, here you go. Please help me.
I know, like I have all this content. I feel like I could get it recorded, but I have no idea how to put it together. And
so just do the recording and send it over. There's so many people on Fiverr. Just do that.
That's why I'm in stills, not video. So it's like a whole other thing.
God, yes, exactly. So you probably do need someone to help you with that.
I do. I need help. So this is great. We've got some more questions here. We've covered like some NDA, things like that. You know, just why is it important to have these agreements in place no matter what? You know, we've touched on that. Let's see. This is a pretty big question. For new business owners and startups, what are the top 3 or 5 legal documents that you should have in place to protect yourself and your business to help you get started? So I think this is great. So we've talked about a lot of different things. So what are like those top 3 things that you should get done as you get started to save your butt in the future?
Okay, so the first thing before I even go into that is to make sure that your entity is formed and protected in one way or the other. I'm sorry, I know that I can tell you that it's okay for you to be a sole proprietor and just have an EIN or whatever. And I'm sure that other lawyers who have sense will probably tell you that, and that's great. But I think that's also good for you to limit your liability. So if you're getting an LLC or a corporation of some form, please go ahead and do that, because that's the first line of defense if somebody decides to sue you. A lot of us, like I speak to a lot of fempreneurs in terms of like, you know, people that have like businesses as either side hustles or main hustles, whether they're single or married. You have to also remember that your assets could be tied to somebody else. What's the reason of keeping that exposed to like liability for some shit that you did wrong at one point or the other? So, hey, you know, so that's the first thing. And I'm just getting that there. And the reason why I mentioned that is because then one of the major documents you should have is your operating agreement, whether it's an article, like it's the shareholder agreement if you're doing it with other people, or an operating agreement that specifies how you handle things. Even if you are a single member LLC, having an operating agreement is a serious thing that you should have. So number 1 is just becoming an entity and having the documents that come with that. Number 2 is your bread and butter, your client service agreement. There is no reason why you should be agreeing to things via email or in the air. If you're a product provider, actually, even the government says that anything, like technically what the law says in contract law, the statute of fraud says that anything that you're contracting over $500 should have a contract in their place. But that's for product providers. For service providers, why would you even not have a contract in the first place? Because you want to be very clear from the beginning what you are agreeing to do, so that they don't drag your ass to court and disgrace you there and show everybody that you are not a serious business owner because you don't have legitimacies in place. So please, save disgrace, get your contract. Simple. But so definitely having a client service agreement that dictates what you are agreeing to do, how you will be paid, what the terms of the agreement is, how they can terminate, what happens if they have to reschedule, what happens if they have to cancel, what happens if you are unable to complete the service. Is there an emergency substitution clause? That's something, sorry to deviate again, Ashley, that's something that I should have mentioned under the COVID emergency stuff. We are still getting sick. I'm sick from my toddler right now, and that is just not fun. But in the event that you are unable to participate or perform the services that you have been contracted to, is there an emergency substitution in place? If you are an entity, obviously, there's also the case that you could have somebody working on it, like somebody in your brand or in your business obviously can perform the services. But having an emergency substitution in place too is something that will help you keep the money, because then you're still able to perform the services of the contract. And there's no like stress there in terms of anything that's, you know, and this is another thing. And sorry, I have to go into this. I have ADHD, guys, but it's worked really well for me. But what I was going to say is also maybe if you're listening to this, reach out to like 1 or 2 2 or 3 vendors, like similar vendors, even your competition, reach out to them and maybe discuss with them and let them know that, oh, hey, in the event that I do, like there's a life or death situation or I'm unable to perform, would you be the person that, are you comfortable being the person that I call to be able to contract that services? This is the part where they say community over competition, because this is the part that would be really important in helping you keep those clients. So have a conversation with people in your area, in your geographical area, that are like-minded and you know that you love their work, just so you can have them as your emergency contact, quote unquote, in terms of when the time comes. And if you want to maintain that, this is something that's going to happen a lot. You have to remember that we're still getting sick. And a lot of us, like I said, I do speak to a lot of entrepreneurs, and I do, like, some of us are, like, especially in my age group, a lot of people are growing their families. What happens if you're like heavily pregnant? What happens if you go into labor? I know that that's not everybody, and I get that. But what happens if there's something? What happens, God forbid, if there's a death in your family? Like, there has to be something in place. This is something I preach about, and it's a whole other conversation about business continuity, because your business will have to continue in the event that something is wrong with you. The buck does not stop with you, because there are bills to be paid.
Yeah. I'm so glad you brought that up, because it is something that couples ask even pre-COVID days. They say, okay, well, what happens like if you break your leg? Like, you know, are we like SOL? And I'd always be like, so I have a very deep bench of friends and peers that have similar styles to me. I will be calling, that they will show up, they will get everything done. I'll still be editing. You know, you really have to ease their fear, and you have to think through that. And I've had to be that person to go rescue a friend's business that has had to deal with, you know, emergencies. So like, I feel like I've banked up some good karma with that, which is good. Not only I haven't had to use it, but I know that, you know, it's not a matter of if, it's when. When are you going to? You know, so
I get that in the,
yeah,
sorry,
have that in, but exactly, but being able to have it in writing, you have that discussion, opportunity to talk that through before, God forbid, you need to do it, is just vital. I think that's such a good thing that came up with that.
Yeah, I think that in general, and actually you just made a, like, before I jump into another thing again, but what I was going to say that, so Ashley is a good person. So she has friends. You don't even have to have friends. Just have these people, have these conversations, and let them know that even if it's a business arrangement that you guys have, and be like, hey, I know we hate each other and I can't stand you, but hey, like, would you be the emergency contact in the situation? Like, because like not everybody's friendly. Look at Ashley. She's happy, and she's like, you know, she's liked. But you don't have to be liked, but this is something that you need to do for your business. Like, do you know what I mean? So this is a good thing to do. And I like what she said about banking that goodwill, because in the event that you do need it, like she said, it's not about, I get a lot of comments about how people are like, oh, but I've not had any problems, knock on wood, and things like that. I'm like, yeah, but you know what? Do you know why I'm still in business? For the times when it doesn't go right. Because it will happen. Just as much as like Newton's law, what goes up is definitely coming back down. So like you have to be prepared so that you are not out of business. And this is another thing, like you should really embrace having the language of substitution, or a member of my staff, or a member of the team in your contract, because then you're not pushing yourself into a corner by being the only one that is able to perform on the day of. So this is something that you should, this is the reason why I'm so big, and the reason why I mentioned as my first thing is the entity formation and having an entity there. Structure the shit out of your business, guys, because a structured business is a protected business. It's a business that has sense, for lack of, like, that's my Nigerian in me, a business that, you know, has sense, because then you have a plan in place and you have a procedure and you can make those things happen.
I love that. So get yourself existing as an entity, so that you're not having your butt on the line, your
client contract,
have your client contract, operating agreement, and then so what's after that?
Okay, so the operating agreement, like I said, it's an overshadow, but the next thing that's most important is your hiring agreements. So if you are hiring, and the hiring agreements fall in two places, like Ashley and I have already discussed, so I don't have to go into it too much, but you either need an independent, most people will probably start off with an independent contract, because new businesses usually aren't hiring employees right off the bat. Anybody got money for that? But having the hiring agreements, like whether it's an independent contractor agreement that specifically states everything that you're doing, especially in creative businesses, you also want to be clear as to intellectual property. Who owns what? Who is claiming to have done this as what? If you're hiring a second shooter, is that under their brand or your brand? How can they share the images and things like that? If you're hiring an associate planner, is the person working exclusively under you? Are they working under your brand, or are they an individual independent contractor that can show their work in related to that? These are the terms that will keep you from having to curse somebody out in their Instagram comments. So please do the right.
And that goes hand in hand with an NDA. I think that sounds good.
Exactly. So what I was going to say, 3 and 4 are the hiring agreements, whether it's an employee agreement or an independent contractor agreement. We've already discussed the non-disclosure agreement. It's something that's not necessarily mandated, but I think it's something that you should have, especially now that this industry is evolving in terms of workshops, whether you're moving into the educator space, you're moving into different things. There's a lot of collaborations and partnerships and like ideas coming into this space. So having a solid NDA in your back is always a good idea. And I love that's probably my favorite contract to send to people is like, here you go, shut your mouth up. And that's it. So have that in place. And then something that we don't talk about a lot, but something that we should have, because even the government wants money now, so they will come for you, is having a good privacy policy and terms and conditions on your website. So if these are the only 5 contracts or 5 things that you have, if you have a website, because there are so many laws coming out, for instance, like California's Cal OPA laws, GDPR, which is the UK, but it sounds like it's just the UK or the European Union. But the truth is that if anybody's visiting your site from that place, you also need to have some kind of privacy policy in place. Having a privacy policy in place dictates how you're handling, like who's allowed to come on your website, how you handle the data that they're giving you, especially if you're collecting leads through the website in some form or the other. So if you're collecting somebody's biological name and like emails and things like that, they want to know how you're handling it. We do have a privacy policy template, legally said, but that's not the point. What I'm saying is that it's something that's really important. If you are a service provider that's also offering some kind of sale or user interface or product on your website, then you need for sure the terms and conditions of use of your website. There's like people need to know what the terms are for them contract, because basically when you do a sale, when you do a service like that, you are contracting with that person. So it needs to be clear what the terms of the sale is. Do you offer refunds? I know a lot of people are into the in the coaching or educator space now. So how are you handling if someone has direct access to your digital content? There's conversations around that now. Like, are they able to? There's a whole conversation. I'm literally speaking at something on Wednesday about courses and like digital content, because people steal. People also steal. So people sometimes will sign up for your shit just to see everything and scrape your site or anything like that. So having something in place that talks about that, or if somebody misuses the content on your site, limiting your liability and also like letting them know that you can discontinue the service at all times. People sue for the littlest things. So you want to protect yourself there too. And your terms and conditions is basically your contract with the users of your site. So those are the 5 things that I think are super essential.
Yeah, and I think that that's been a blind spot for me. I haven't revisited that in years. I'm collaborating with a lot of my pals, and we're creating a course, and we're doing all these things, and I have not even thought about extending that legal scope to those other things. So that is huge.
Should. Yeah. You have to protect yourself from every corner. We're all trying to make money now, and we're all expanding what our offerings are. So the more your offerings expand, you want to be very clear and intentional as to how, like, what governs them and how you will handle things and procedures.
Exactly. I love that. So I think we've got time for one more question, and it is the last question. So this is perfect. It's been really good. Yay. So our last question is, what's the best advice you've been given in regards to running a business? What advice would you give to someone who's just starting out?
Oh God. So it's probably the same thing for both. My first advice that I ever got, and and this was a couple of years ago, I was speaking with a business coach, and he's like, you're not taking your business seriously. And I was like, okay, you get defensive all of a sudden. It's like, what do you mean? I'm working, I'm doing this thing. But the truth is, you're not taking your business seriously if you do not invest or at least lay out the structure of the business. And I already said this before, like beyond even just having an entity separate, like an entity formed, having a separate bank account, making sure that you're covered under the business insurance, making sure that you have the actual appropriate licenses to practice that business in that state. And most importantly, and I think actually I'm not just even saying this because that's my bread and butter, but contracts are like so important. But having those contracts in place so that it determines whatever it is, like so that you know that you are a serious business owner. And then also do not ever underestimate the importance of a CPA or a practicing accountant or bookkeeper in your life. Not or bookkeeper, probably both, but having those people there, because we are working because yes, we love it, but we're also trying to make money. So to do that, you need to protect the money in the first place. So please make sure so that, like I said, the IRS isn't knocking at your door because everybody's broke, including the government, and they will come for your money. So having that in place is very important. And then also, so that for me is the best advice you can give any business owner. But then on the other side, which is my brand enthusiast side, I have to say, now this is not legal advice, but also like, hello, why have you, like, even if you have a business idea or you started the business, park the minute you do, park your domain, park, even if you do not have an active website right now, park that domain, do the work, please. Don't just think because a domain is available that the brand name is available. Go ahead. So many things are offered to you for free. Search, do the entity search. Don't just check the first page of Google. Check 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and see if anybody has a like named brand in your jurisdiction, but also in the internet, because then you have more of a federal explosion. The USPTO, which is the United States Patent and Trademark Office, also has, like, you can literally search names that are already trademarked. One of the worst things you have to do is rebrand and rename after you've done all the marketing strategy and all the fancy shit in the world because somebody else has legal rights to that name. So please go ahead and do what I call this is vet your business. Vet your business name. Vet it hard. Check everywhere. Check if it's registered. Check if it's trademarked. Check it on Instagram. And just weigh the risks of having a similar brand name in the market.
That is so good. Once you get too far down the tracks, then you're like, oh,
exactly, no. Because it's expensive. Everybody's expensive now. So you need to be very careful as to how much you want to reinvest in correcting a mistake you could have avoided in the first place.
Exactly. I bet that has derailed quite a few people.
Oh, yes. I think an attorney herself, she was very candid about how she made that mistake. She didn't think too much about it. She created some kind of beauty line and then had to spend so much money like fixing it when that happened. So yeah.
Man, yeah, we don't want that to happen. Awesome. This has been so informative. I'm so excited to get over to Legally Set and to just close all the gaps that I have and then get someone on retainer too to make sure that everything's fitting together since I am going to be married together. But for the people that are new, like they are totally set for them to take them and run. And then just remember that this is something that you have to keep thinking about and keep revisiting, maybe on an annual basis, would you suggest?
I love that. Like fine tune it. Yeah, an annual basis is good because then you have a good appraisal of what the laws are and things like that. And just having that there and just being like, hey, can you let me know if I'm legally set? Speak to your attorney and have them do that and just know that you're on the same, like you're on the right page.
Exactly. And that's going to save you, no matter what it costs, it's going to save you so much and having
so much more money in the future. Exactly.
Yeah. Oh man, this has been awesome. So I think it's so exciting that you're pivoting yourself and making sure that you're, restructured and recovered. So it's awesome because I think a lot of people that are in that same boat where, we've been doing this for a decade or not, and we're pivoting, and even though we have all that experience, like it is new. Like we have to treat it as like a new startup, and so it needs all of its own things. It needs its own agreements and protections and everything.
It's its own nurturing. Yes. Exactly. I think that's the thing. And that's the reason why I can always relate to like my clients, because I'm also living that life. Probably 9 out of 10 times I'm going through some part of that aspect or that experience. So I think it's really important that you remember that your business is not a one and done situation. It's a nurtured product. It's as you grow, and as many years as you are able to continue to do this, you have to remember that you have to nurture it like anything else. So just like you go over the systems and things that are working and everything, you also go over and make sure that your agreements are solid in place and your legal structure is solid and works for you the best way it can.
Exactly. I love that. It's like having that good foundation. I will definitely attest to having a good CPA in your corner that will keep at night more than almost anything else, knowing that someone is doing my bookkeeping, that can help me fill out anything I need to fill out. It just really legitimizes your business. It helps you be able to nurture the creative side of it when you have all of these things set. So this is awesome work that you're doing. I'm so glad that you were able to spend so much time with us. Thank you so much for being here.
Thank you for having me. Thank you so much.
It's been awesome. I'm going to go ahead and let you go.
Okay.
I hope you feel better, and I hope your 3-year-old.
I'm like trying to breathe through my nose, and I'm struggling. But thank you so much for having me.
You're so welcome. And I'm going to add links onto our Instagram, the Facebook, and for Empower Events with Kunbi's info. So if you want to get over to Legally Set, she also has that awesome reel for like just a really fun drink. All the reasons that you should have an NDA. She's got great content, and she's got all kinds of other things. She is also the founder of Perfect. Also, Launch That Ish. Is this the new segue?
Yeah, so that's my saying, but it's also the podcast. I am literally yes. So it's basically called Lunch That Ish because I curse too much. But yeah, so I will be speaking with new launchers, old launchers, and people around launching or on the brink of launching to discuss tips and tools for a successful launch. So I'm really excited about that.
I'm gonna get on that for sure. Awesome. Thank you so much again, and I hope you have a fabulous day.
Thanks. Thank you so much for having me, Ashley. Thank you.
Awesome. Bye. Guys. All right. Thank you everyone for tuning in. That was really awesome. We are going to be back next month with another Tuesday Talk, and we hope to see you there.